was untold. Grab your seat, settle in, start the show. Courtroom clashes, the fun we bestow. Baker's Channel, action's hot. Draws and fun, all we got. Discuss, debate, break it down. Baker's Channel, just the best in town. Lawyers spar, tensions high, sparks fly. We laugh, we learn, dive into the why. Join the chat, have your say, it's your place too. Every twist, we're here for you. Baker's Channel, action's hot. Draws and fun, all we got. Discuss, debate, break it down. Baker's Channel, just the best in town. Hey, and please like join the crowd. Baker's Channel, we're live and loud.
Good morning, good evening, good afternoon. Sorry I was a little late. I was getting my dog in doggy daycare. And welcome to day 2 in the Ashley Benefield trial, also popularly known as the Black Swan trial. Yesterday, opening statements, he was very abusive. She was very manipulative. Didn't really see that from any of the testimony we had yesterday either way, other than that they had that weird 13-day courtship. Really weird for me. So it's, yeah, I really don't know which way to swing on this. I liked the defender. I liked the prosecutor. They were fighting a lot of sidebars, but I felt they were warranted. But still, weird trial. I know, Christine, I just don't put it up because there's nothing to watch. But if it makes your day better, you can see. Trials seals up. I have done this before. But I can also say hey to Carrie and Sean Bird and Miss Marissa. Tee experts today. Yeah, that could be great, because yesterday it was just police officers. We were there. We took her in custody. We went through the house. Yes, there was evidence of pew-pews. Jamie, you have a link. You have 2 links. Helen from Holland. And Brian. Sue, good morning. And Zencat. Miss Irish. And Molly is eating. She's getting some weird, I don't know what, I think it's some lamb. It smells like old cheese. It's really, really nasty. But she likes it. Can't get over the number who convicted her for a failed ballet school equal murder. I just don't get it. Well, I don't think, I think a lot of people thought it was a weird thing with that ballet school, but I haven't been swung from reasonable doubt till guilty so far. I don't think anybody wants to convict her for failing at business. No. I just want the state to prove she wasn't in fear of her life. So interesting. I don't have a dog. I'm just doing doggy daycare for. Well, she's eating, so she's not screen presentable right now. She'll probably stop by. She normally potters in here and says hello sometimes. It's a small one. It's white. 4 legs. Doesn't bark that much. That type of dog. Hey, Panilla. And just Jen. Peter. We have movement. Mhm. You're going for closing instead of today and Friday. With work, it's hard for me to break up the days. Well, if ever, and you want to phone in and give me um your take on it, let me know. I'll send you a link so you can join via your phone. Holly Mac. Well, thank you. Fuba, don't stay up too late. Do-do-do-do-do-do-do. It's too soon to decide on her guilt or innocence. We have only heard from a few witnesses. Yeah, and what we have heard so far, I would say both Tommy with IE, which I thought was a way girls spelled it, uh, and the daughter didn't really say anything about her being nasty, vindictive, a heated custody battle. So we'll probably get more into the poisoning and stuff like that she claimed. But other than that, we don't really have anything to go by. Molly is so cute. Yeah, she's a little cutie. That's how I determined it was a dog too. Tim's Whoop and Hyacinth Bouquet, lady of the house speaking. Jar. Good afternoon to you as well. No, but I think it's an interesting case because it's a self-defense claim. She needs to take the stand. She needs to tell us, make us believe she was afraid. Um, at least make the jury believe she was afraid. I thought her defense lawyer yesterday was good at putting ideas in the head of the jury, even if he did it on a kind of sneaky basis. I think he was pretty good at at implying stuff were going on. So I think I also think he seems like he's a little bit too old for his job, but I think he did a good job yesterday. You found several holes in her story. Well, she hasn't really told her story so far. Lorraine O'Shaughnessy from Ruskin, Florida. Good morning to you as well. Yep. Yeah, and we know that in self-defense cases, it, people are expecting to see you on the stand, telling you why they did it. Um, I think I was covering the guy out of. Oh, she arrives to court now. She looks more grown up today, without those little braids in her hair and stuff like that. And then she pulls up a binder with Molly. I have a dog. I have to go tell not to bark at the neighbors. Look, Jamie, see who's back.
I'm muted as I'm yelling. Molly, oh,
Yeah.
look at how sweet she is.
Yeah, she was so happy to see me.
Don't be jealous of the other dogs.
Oh, little baby. You're such a little baby.
talk to her in an accent.
Ooh. Are you
Talk
going to be
Danish
here
to her.
today while streaming?
Does she understand English?
No. She is eating some dried something, and it smells horrendous. Her breath is vile. Ja, Johan. Du er varm
Oh
i
my
dag, lille
God.
skat. Du er så varm. I know Sean Bird. She could stay alive on me for weeks.
Sean.
It's not a toy pup. You can hear her talk. Of course, she doesn't do it when I.
Oh, I love her.
Yeah, she's a good doggo. But she yells at the neighbors, so I had to close the door. So now it's gonna get hot. She just has to.
Yelling at the neighbors.
She has to figure out that she's a new place, and we have a girl next door who shouts a bit. It's good entertainment.
Mm-hmm.
The ex-wife is dead, so no, Marissa, it's not the ex-wife by the daughter. Oh, Lorelai is also pet sitting. Well, she doesn't really. Well, she gets the zoomies when I take her out for a walk. When we come home, she just runs around the house and wants to fight me. That's why I have, instead of doing the normal words on screen, I'll split this up in two so I can take her for a walk, because that'll be. Oh. You're getting tangled in my. So I'll take her for a walk there, and we have some time to get the zoomies out. But I fenced in my yard yesterday, so she can run outside as long as she doesn't bark at everyone. Danny T, I let her sleep in bed with me, but she doesn't want to do it. She used to do it when she was smaller, but now she lays. I have a plush carpet next to my bed. She lays on that one.
She doesn't like to sleep in the bed?
No.
Oh, Molly.
That's fine.
Baker wants to snuggle.
No, I think it's because we get too hot. She comes up and then she crawls under the. We don't have duvets. We have duvets filled with down feathered downs, duck down. So it gets too hot in the summer for that little thing. Oh, Dory likes Molly. She is a sweet little dog. Well, not that little. She's 2 years now. And she's just getting out of being in heat. So,
good morning, everybody. Welcome back.
Good morning.
Check and make sure we got the right
I am
numbers in the right
Stockport's wife.
place.
Could you
Those are
please put the
yours.
kettle on?
Check your pins. Make sure they still got plenty of ink. All right. Good morning, everyone. Just want
it's
to
not
make
a
sure
quilt,
that
it's-
nobody
you-
began discussing the case amongst
a-
yourselves or started deliberations.
Yeah.
Nobody discussed the case last night or this morning with anybody outside of the jury.
We
Nobody
have them all year
approached
round.
you or talked with you or tried to influence you in any way, and you didn't do any research on the people, places, things, or legal topics we've heard anything about. All right, everybody says no. Thank you.
Oh, thank you for being here,
When we finished
Lorelai.
up yesterday, the state was still presenting its
Hey, Colleen.
case. So, state.
State calls Alicia Byers.
Hopefully, we'll get some more witnesses talking about the relationship
You
today.
solemnly swear or affirm the testimony you're about to give will be the
Yeah.
truth, the whole truth, and nothing but the truth.
Good morning, ma'am. My name is Judge White. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Scoot up just a little bit. We need to get you about 12 to 15 inches from that microphone. It doesn't adjust up, down, left, right as you need it. If you speak in a loud, clear voice right into it, it'll pick up everything.
Thank you.
Yes, ma'am.
Good morning. Please state your name.
Alicia Byers,
Can you spell your first name and last name, please?
ALICIABYERS.
And your relationship to Ashley Benefield.
She's my daughter.
And when did she start living with you in Florida?
I can't clearly remember.
Okay. Was there a time when Ashley moved in with you when she was pregnant?
Yes,
Okay. And she was married at the time, but it was just Ashley that moved in?
yeah, he brought her down.
Okay.
And yes, and yeah,
And she moved in with you?
yeah. He told me I needed to take care of her. He dropped her off.
Okay. So she stayed with you from that time on, correct?
Yes,
And does Ashley have a concealed weapons permit?
yes.
Does she own firearms?
She doesn't now, no.
Did she own firearms then?
Yes.
Okay. How many?
2, I think. Yeah, 2.
Did she ever go to the firing range or anything?
Yes,
I'm sorry.
yes.
Okay. How frequently would she go?
Well, we did all the courses to get the concealed carry, and
It's only leading if there's an objection. Else, you can do whatever you want.
I don't remember.
Okay. And very shortly before the shooting, she went to the shooting range with your neighbor, correct, John Fantz?
I don't think that was close to that time now.
So it may not have been close in time, but they have gone together? Ashley and John Sands.
I'm not sure.
Okay.
I don't know.
Okay. And you and your daughter obviously are very close. You live together, just the two of you, right, for a while.
Mhm.
And then once the baby was born, the baby lived there with you,
Correct?
correct? Okay. And around that time of the shooting, were you planning to move to Maryland?
Yes.
And you had a house that you inherited in Maryland?
It was the house I grew up in.
Okay. And you inherited that house?
Yes.
So your plan was to move to Maryland with Ashley and Emerson, the baby?
Mhm.
Okay. And Doug, Ashley's husband, was also moving to Maryland?
He was moving somewhere else. He was, yeah.
Okay.
He had found his dream job.
So he was moving to Maryland, but not moving into your same house?
I
Correct.
thought they were moving in together.
And he was packing up to move at the same time you were?
I assume so, yeah.
But he was coming over to help
Yes.
you move?
Yes.
And on a regular basis, almost every day, he was at your house?
Maybe the last week.
Okay.
Yes.
Helping move boxes and things like that?
Yes.
And you all rented a U-Haul, right?
Somebody rented a U-Haul. I don't know who.
It was in your driveway though, correct?
No, it was not my driveway.
The day that shooting happened, was it in your driveway?
It, I think it,
If you don't
the
know, that's
U-Haul
okay.
was getting there when I was leaving.
Okay.
Yeah.
But you also had a pod, one of
Correct.
those
That was in my driveway.
in your driveway? Okay. On the date of the shooting, what time did Doug get to your house? Do you remember?
No, I mean, it was, I can guess, maybe like 5 or something. I don't know.
So it was still light out?
Oh, yeah.
And maybe in the afternoon sometime?
Yeah, I don't clearly know.
Okay. So when he showed up, what did you do? Did you stay there or leave?
I was leaving when he pulled up.
And where did you go?
We went to the park.
Okay. And when you say we, who is we?
Oh, Emerson and I.
Okay.
Yes.
So just you and Emerson. And
Yeah.
how old was she at the time?
So I guess 2, maybe, yeah.
approximately.
Yeah.
And at the house, was it just Doug and Ashley then
Yes.
when you left?
Mhm.
And you've obviously been in contact with your daughter almost every day since the shooting, correct?
Leading. No, we'll
You've been in contact with her basically every day, correct?
Not
the-
initially, no.
For the last several years, you've been in contact with her every day.
Well, yeah.
Okay.
I
And
don't know how to, okay, yeah.
did she ever, during any of these conversations, tell you what happened when she had to shoot Doug?
Never. Nope.
When you came back from the park, I'm assuming she was already in the squad car or she was already with law enforcement?
I had no idea where she was.
I'll sustain.
Okay. So at the time that the shooting happened, she didn't tell you what happened,
No,
correct?
we've never talked about it.
And
No, overruled.
to this day, you've never talked about it.
No.
Thank you. No further questions.
Cross.
Good morning, Miss Byers.
Morning.
Are you nervous?
Yes, very.
Scared?
Yeah.
All right. Let's try to relax. If my questions aren't clear, please just ask me to repeat it.
Okay.
Was there ever a time when you and Ashley resided here in Bradenton, in the home, that Doug lived in that house?
Never.
I forgot he's as slow as molasses.
Mm-hmm.
Would it be safe to assume, and perhaps you can enlighten us a little bit, how was your relationship with your granddaughter, Emerson?
Oh, very good. Yes.
Okay.
We're very close.
And would you try to spend time with her?
Yes.
Would that include you taking her somewhere on a regular type basis?
Yeah.
Would that be to the park?
Yes.
And tell ladies and gentlemen of the jury, Ms. Byers, how often you engaged in that practice of you and Emerson going to the park?
Hey, Trish.
Usually several times a week. And we'd go after it cooled down because the park does not have very good, tree coverage. So it was very hot. That was the only comfortable time to go.
So we think trying to avoid the heat or minimize it'd be later in the afternoon.
Yeah, it was brutal out there otherwise.
Yes, the state called her mom. Didn't get anything out of her other than she never talked to her daughter about it. There was no questions about the relationship, no questions about anything, other than we established, which I thought they were moving in together, that they were moving to Maryland, and then Doc was following up there, which to me kind of changed the story because I thought they had decided together to move together to Maryland. But now we know it wasn't like that. But other than that, of course they talked about it. Of course they did. But other than that, she didn't say anything. Yeah, she had a concealed carry and they went to the range. I don't know if that's to disprove the stovepipe, but if you're shaking, if you're afraid, you might forget how to grip and hold it. I don't think it works in the state's favor. I don't know.
I don't know. A lot of people don't like the fact that they think she's lying because they can't believe she didn't talk about it with her. And that's why I think what'll get her. But it doesn't. I mean, it is what it is. I don't believe that.
No, and again, it's the mother.
But,
Now we're a little behind. I can speed him up because Jesus, he's slow.
yes.
Florida,
Almost as bad as it is now.
Right, exactly.
How far away was the park?
It's a short walk. I mean, we'd always walk over there. So I don't know, it'd take us maybe 5 minutes to get there.
Okay.
So
And on this particular day, I think you told Miss O'Donnell, if I'm not mistaken, you were actually in the process of going with Emerson to the park when Doug arrived.
yes, we're walking down the driveway and I had her in the stroller.
And on this particular occasion, there was nothing unusual about you going to the park, just
Oh,
like you
No,
did
but
regularly.
yes.
Give me a moment, Your Honor, please.
Wouldn't you get more in how abusive he was if you had the mom
I
there?
think that's all I have, Your Honor. Thank you, Ms.
Can you redirect?
If
Oh,
she
hold on,
knows
hold on.
anything.
No,
No.
can this witness be released?
Yes.
Yes.
But someone
You're
has to
released
tell
from your
us how
subpoena.
bad he was.
The rule of sequestration had been invoked, but you're now released from your obligation.
All right, thank
There
you.
you go. Thank you.
Judge, I apologize. In consulting with counsel, I do think I want to leave her under subpoena.
Well,
Sorry.
Ms. Byers.
So what does that mean?
I'm going to explain that.
Okay.
All right, so what that means is you remain under subpoena and subject to be recalled at the trial.
Okay.
The attorneys at the beginning of the case invoke what we call the rule of sequestration. So the instructions I'm going to give you are similar to what you've already probably been told by the attorneys. You're not to discuss your testimony here in court, the questions asked of you with anyone else, including the attorneys. You can't talk with other witnesses about what their testimony was or the questions they were asked. And it's my understanding this may be online. You are prohibited from watching anything that's going on within these four walls, ma'am, until you're released from your subpoena or until the jury comes back and the verdict is released. Okay? All right, thank you, ma'am. You're free to go for now.
That was a weird opening to the day.
All right, State.
State will call Barbara Russell.
Oh, this way. There you go.
To take, I think the reason why they crossed was to take out that it was extraordinary that she took the daughter away from the house, so there was no pre-planning in it. I think that's that's what I believe was the reason why he asked those questions.
that's what I was getting out of it too.
Yeah. uh, Weird one. Weird one.
Mm-hmm.
Yeah. She was one because she was living with her, who could have heard or seen something, but well, we'll have to. My pause game is on point. She looks like she's possessed.
So this is the therapist.
Yeah.
So we got idea. Thank you so much.
Good morning, ma'am.
Good morning.
My name is Judge White. I'm going to be presiding over this case. As the deputy said, just make yourself comfortable in that chair. Get about to 12 to 15 inches away from the microphone. It does adjust up, down, left, right, however you need it. But if you just speak directly and allow your voice into the microphone, it'll pick up everything.
Thank you, sir. And please state your name.
Barbara J. Russell.
Can you spell Barbara Ann Russell?
BARBARARUSSELL.
And what is your profession?
I'm a licensed clinical social worker. I have a doctorate in clinical psychology, and I work as a clinical and forensic mental health professional.
Okay. And how long have you known Ashley Benefield?
I've known her since April of 2020.
Okay. And when you first became involved with Ashley, it was on a professional level, correct?
Correct.
All right. And then since the time that you had that interaction, you have stayed in touch with Ashley.
Correct.
And subsequent to the shooting that happened, she actually moved into your house, correct?
Correct.
Okay. And who all lived at the house?
Myself, my husband, and my 19-year-old daughter.
All right. And approximately how long did she live at your house?
Approximately 8 months.
And you would see her on a daily basis?
Pretty much, yes.
Okay. Did she, when you first spoke, when did you first see her or speak to her after the shooting?
About 1 o'clock the following morning.
Okay, so this happened in the evening time, so it would have been 1 o'clock the next morning. And at that time, did she say to you, oh my God, he came after me, I had to shoot him? Did she say that?
She didn't discuss what had happened at all, nor did I ask.
Okay. And to this day, are you still in contact with her?
Not that one. I'll overrule on that question.
To this day, are you still in contact with her?
Yes,
And to this day, has she ever told you what prompted her shooting, Judge Benefield?
she never gave any kind of narrative of what prompted the shooting. My understanding is that
I
she was
just want to know if
defending
she
her life.
told you. I just want to know what she told you. She did not tell you anything, correct?
She never gave me any narrative about what had happened.
Thank you. No further questions.
Cross, sir.
Good
What?
morning, Dr. Russell. I have a question from your own personal knowledge. You're aware that Ashley's lawyers instructed her not to discuss the facts, correct?
Of course, any good lawyer would do that.
Give me just a moment, Your Honor.
Of course, yes, sir.
Did there come a time, Dr. Russell, when a detective, Warren, contacted you about the case?
Yes,
Did you have discussions with Detective Warren?
I met with him once, yes, for about 90 minutes.
And in that meeting, did you relate to him that,
Objection, yourself.
I'm asking a question to this witness?
My
Yeah, he
understanding
said,
calls for
did you
hearsay.
relate?
Why don't you approach so I can hear what the question is going to be?
He did say, did you relate to him? So that can't be hearsay. That's what she's saying. Yeah, and doing when they tried to suppress it, that came off a little weird. That, oh, she was living with me, my husband, and didn't she also have daughters? It was because she was living in bad hotels, so she had for her mental health. I've always been the type of guy who doesn't mix business and pleasure. It never works.
Mhm. Oh boy. It's funny that they're very short with these witnesses. Like,
Yeah,
I mean, I know they can't get into much with the therapist because we've seen that in the other
I don't have to
trial.
put up a banner because Lawn and Graham does it for me. Yeah, of course they
No,
can't,
that's-
and that's what they wanted to ask her a lot about stuff, but she said, "I have my privileges," and she never withdrew her, so I can't talk about it.
Mhm.
And the state tried to make them her talk anyway. That's a weird one too. But why
Well, yeah.
why did they call her? That's the thing I don't understand.
Mhm. Well,
Um,
Ashley lawyered right up after this, so maybe her lawyer told her not to tell anybody anything.
yeah, the smart move.
I mean, to be honest
Lawyer
with you,
up
then if you
and
don't tell
shut
your
up.
mom, you don't tell your therapist, you don't tell people, then nobody can come in and testify
No,
to
and
it.
force them to testify.
Exactly.
Thank you, Wendy
So
Mueller, for becoming a member.
kind of a smart move.
Yeah.
When you spoke to Detective Warren, Justin, you identified yourself.
Correct.
This was a face-to-face conversation.
Yes.
If you were to tell us today in court about the discussion you had with Detective Justin, would it be any different than what you told Detective Justin on that day?
No, of course not.
You have an opinion, do you not?
Objection.
Rephrase. As you sit here today, do you have a conclusion?
Objection.
Sustained.
All right, give me a moment.
Yeah, you can't get into it. Hmm. Well, neither story fits anyway. And as long as there's doubt, she should have the benefit of the doubt. So,
Yeah.
yeah. No, if she's not an expert witness, she can't talk about it. This is when I think he's a bad defense lawyer.
That were in here yesterday.
Hey, Grammy. Yeah, but again, you can't hold it against her. She's a smart defendant. Remember when Lally said we want to put in that Karen Reed contacted a lawyer as proof of guilt? It's not proof of guilt. It's just a smart
No.
person.
Yeah.
If you get stopped today when you're driving home from work and the officer says, I just want to talk to you, make it easy. You say, I got 2 words for you. Fifth, and call my lawyer. You don't go in and say, oh, yeah, of course, we can figure it out. Let's talk about it. Because then you end up like Sarah Boone, admitting to unaliving your boyfriend with a suitcase and being a straight A student.
Well, and yeah, having like 50 different versions of what happened. And that's the whole thing is like maybe her lawyer right away was like, zip it, lady, don't tell anyone. Because if you
Yeah.
start telling your family or your friends, then they're going to be compelled to, they're going to have to testify. And like, if nobody knows anything, then
Yeah, if you shut your mouth, no one can. And of course, I don't believe she never talked
use
to her
it
mom.
against you. Yeah.
But her
also-
mom, you would have a hard time prove perjury on that one.
Mm-hmm.
Why was the mom on the stand?
Dr. Russell, you had an opportunity that morning from what you had to say at approximately 1 o'clock, technically the next day, to observe Miss Benefield, correct?
Yes.
I'm going to pass you a picture that's previously been marked as State's Exhibit number 21, picture of Ashley Benefield that was taken on the day of the incident.
Yes.
May I approach your honor?
Yes.
That's who
Does
you
that
are.
picture
Yeah, it's Dee
reflect
Snyder.
any swelling to Ashley Benefield?
Objection as interpreting the picture.
Sustained.
Did Ashley Benefield look like that when you saw her prior to the day of the homicide?
Prior to the day, no.
Okay, what was different about her?
When I saw her after the incident, there was edema, sweat swelling on the side of her face.
Okay, and did that include her right eye,
It included her left eye.
left eye rather?
Yes.
Okay, and when you saw her before the homicide, did she have swelling on the left side of her face, on her cheek and her eyelid?
She never had, no.
Because she saw her with the swelling we really can't see in that picture. Yes, she's a trauma specialist.
In fact, when you saw her immediately following the incident that morning at about 1 a.m., was there any indication that by Ashley that her head was hurting?
Objection, hearsay.
Sustained.
Spontaneous statement, Your Honor.
That existing mental, emotional, physical condition.
Can we vote?
Yes.
This is when I don't like Father Time.
Is that what you're calling him now?
Yeah, because he
Father Time.
he goes down some good routes, and then he does this stuff where I don't think he even knows what he's asking.
No.
Thank you, Lefty, for becoming a member or being a member for 8 months. And
Did Ms. Benefield that morning give you any indication that she was in pain?
Yes,
And did you refer to any particular area?
yes,
What?
her head.
Thank you.
Yeah, but again, is that the picture because it was badly lit?
No.
She looked like she had two black eyes to me, but that's not what they're
This
claiming.
witness be released.
Yes. Oh, I'm sorry. No. She's Jermaine. I just, she can release these things.
Ma'am, the rule of sequestration has been invoked by the attorneys, so that means that until you're released from your subpoena or until the jury is discharged, you're not to discuss your testimony in this case with anyone outside this courtroom.
We got
Not to
nothing
talk
from
to the
this
other witnesses
lady.
about your testimony. You're not to talk to
From
the
the
other
state.
witnesses about their
Nothing.
testimony or the questions that were asked of them. And it's my understanding this may be online, so you're prohibited from watching anything that's going on within these four walls.
Absolutely.
Thank you, ma'am.
Thank
Just
you.
leave the picture there.
I will do so. Thank you.
All right, state.
Ethan Montgomery.
There's a state called Lieutenant Dan Dickerman. I know he was caught in the line, so I just want to make sure it's it.
If he attacks Eric July in a minute, I know it's him.
Remember, we have an issue here I'd like to take up for just a moment. I don't know if you
He's here.
want to speak to the next slide.
Hold on 1 second.
Not in my opinion.
Approach.
No.
In my opinion, I was more sus of her before we started the trial than I am now. Because there was something, especially with Tommy and the daughter. There's no indication that she was just a manipulative money grabber. So, but the daughter confirmed that he punched holes in walls and took desk pops. So, to me, that's I don't know. Oh, that's the problem, Jojo. We don't know if the dog thing is true either.
Right.
I did.
Who's attacking who?
Sir. I'm the judge Ryder presiding over the case. As the deputy said, just make yourself comfortable in that chair. You're about 12 to 15 inches from the
Yeah, but they're
microphone.
supposed to end
It doesn't
tomorrow.
just Up, down, left, right, how you read it. Just speak in a loud, clear voice and should be.
Yes, sir.
Good morning.
Good morning.
Please state your name and spell your last
Daniel Dickerman, Dickerman.
name. Where do you work?
At the Manatee County Sheriff's Office
How long
Would
have you
you
worked
get-
there?
for
Harassed
almost
along
29 years.
I'm in school.
What is your current position?
I'm a lieutenant in road patrol.
And what was your position back in 2020?
I was the senior homicide investigator assigned to the Manatee Homicide Investigative Unit.
So Manatee County, say that again?
Manatee,
That's where I find it, because that leg wound, I said that 20 times yesterday. That leg wound doesn't make sense unless she was on the ground.
Homicide Investigative Unit, MHIU.
MHIU. Okay.
Yes.
So you were the senior investigator in that unit.
Yes.
And if you could just explain a little bit, what is that unit?
So that
More
unit
than
is
one.
a group of detectives formulated from all the agencies within the county, the Sheriff's Office, Braden Police Department, Palmetto Police Department, and all three beach agencies.
Yeah.
We all respond out to all homicides that occur within the county, regardless of city jurisdiction, everything, so we can all work together and investigate that and determine if any criminality is a result of that homicide will need to come forward.
And just discuss a little bit how you work as a unit, and is that different than how a detective may work in a different part of the sheriff's office?
Yes, in the sheriff's office, most cases are assigned to a single detective. They go out, they do all the work, they write the report, they bring everything together in a normal, smaller case. In these cases, we determine what we call a lead detective. That lead detective then becomes, for all intents and purposes, the supervisor of the case. He makes assignments. We go out, all the other detectives, we do our respective assignments, we report back. The lead detective becomes a basic gathering point and a keeper of all the information to make sure the flow goes smoothly to one location and we're not duplicating efforts or stepping over each other's toes, and then he makes the ultimate decision once he has all the information.
Okay. And are you, as a unit, a part of any decision-making that happens within the unit or that happens in a case?
Yeah, we have meetings on every case to discuss the comings and goings and happenings of the different case.
And so did you work in this unit, the MHIU, at the time that the shooting occurred?
I did.
On the date of the shooting, were you called, were you notified of the shooting?
I was.
Okay. And about what time was that
It
approximately?
was between 7:30 and 8 p.m.
Did you go to the scene?
I did.
And when I say the scene, where the shooting happened.
Yes, to the neighborhood of White Rock, I believe it was.
Was the defendant there?
Yes.
Where was she?
She was in the back seat of Deputy Burley's patrol vehicle.
Did you go into the house?
Not at that point. I did after the crime scene unit had already documented everything and made sure nothing could be contaminated, done their investigation inside. Then I went in briefly at the end.
Okay. And what did you see?
I saw some blood trail on the floor, a bullet strike in the wall of the bedroom from a projectile. And that's about it.
And were other members of your unit there at that scene?
Yes.
Were there other members of the unit at other scenes or other places?
Yes. Detectives were also sent to our main offices, criminal investigation division, which is where our interview rooms and our offices are located.
Okay. And from the beginning of when you arrived on scene, you knew that there was a self-defense element of this crime.
Suspended.
Did you know there was a self-defense element when you got there?
Object the leading.
I will rule on that.
Yes.
Okay. While you were at the scene, were you made aware that the defendant was going to be going to the station?
Yes.
Okay. Was the defendant's mother, Alicia Byers, there?
Yes.
Did you speak to her?
Yes.
And at some point, did she hand you a phone?
She did.
Okay. And did you know why she was handing you the phone?
Originally, no, but then
Okay.
I found out shortly after.
Who was on the phone?
A lawyer.
And did you speak to that lawyer?
Object.
Sustained.
Again, if it's good for the goose, it's good for the gander. Implying guilt because you talk to a lawyer is a bastard move.
It really is.
Just because you're a smart defendant doesn't make you a guilty defendant. I hated Lally when he did it, and this lady is doing it all the time.
Did you explain to Alicia Byers what was going on and where her daughter was going to go?
I did.
And ultimately, how many lawyers ended up at
His name is Dickerman. Just noticed.
Relevance.
If you want to approach it, explain the relevance.
This
Like,
is going to be a long.
How many lawyers were like? Come on. No, you can't. You can't. Just stop trying to talk about that stuff.
Yeah, she's pulling a binger, just making stuff up and implying heavily that means something. It's
at the time the defendant went to the station, was she under arrest?
No.
Was she ever arrested that night?
Object leading.
Well, what does that matter? Anyways,
When was she arrested?
Sometime in November.
And the shooting happened?
In September.
but you're allowed to call a lawyer
That
whenever you
seems to be a
want.
month or two delay. What do you know what delayed that?
But for the investigation to continue into the self-defense claim.
Okay. Did you go to the neighbor's house, John Sant?
I did go there briefly, yes.
Okay. And did you have any discussions with him or anyone?
I did not, no.
Okay. Was Child Protection Services on the scene?
Yes, they were called to the scene.
And just briefly, what is Child Protection Services?
Objection. Relevance. Consistent with the court's prior concern 403.
Yeah, they weren't allowed to talk about. This is the guy I think who looked into.
What is Child Protection Services?
At the time, it was a division of the sheriff's office entrusted with protecting the children from abuse or make sure they're in good locations or just make sure they're healthy.
Okay. So
Because there was 5 cases with the CPS about she accused him, and they did get a ruling in a pre-trial hearing that they were not allowed to talk about it, and she said, "No, I'm not. I'm just gonna just touch upon it." And the judge said yesterday, because they were afraid about this witness, because I think he was the guy who looked into them going into stuff he shouldn't be going into, and now she's gonna kick the door right open because she wants it in there that she accused him of stuff that wasn't proven.
why, do you know why they were there?
Objection, sustained.
Did CPS try to speak to Alicia Byers?
Yes.
Okay. Were you present when
Yes.
Alicia Byers?
Yes.
Was Alicia Byers cooperative with them?
I wouldn't say fully cooperative. She did ultimately answer a vast majority of the questions, but not cooperative per se.
Okay. And was there anyone else present at the time when they were trying to speak to Alicia
Well,
Byers?
Off and on,
I hate that.
That's
Barbara
the
Russell
mom.
was present.
Well, yeah.
Did you also assist in executing a search warrant?
Also, like, what were they asking her?
Yes, I was on scene
And
It
where
was
was that
not
search
house.
warrant? Was that at the house?
at the house.
Okay. Did you have any assignments for gathering evidence?
Yes.
And what evidence was that?
To originally look for video in the area of the park of the neighborhood.
And did you do that?
I did.
Were you able to obtain video?
I was.
And on that video, did you see what we believe to be Alicia Byers and the child at the park?
Yes, they were at the park.
Did you also obtain other types of videos?
Yeah, I also viewed ring video from the scene itself.
Objection, relevance.
What video?
Ring from the
Ring.
scene.
Overruled, I mean, you could say he viewed it.
Okay. And in viewing that, did you see any part of the incident that we're here about? Was it captured on the ring camera?
The shooting, no. The arrival of the U-Haul and the arrival of the deputies were on there.
Okay. I have no further questions. Thank you.
Close.
Good morning, Lieutenant.
Good morning.
So through your testimony, among other things, the state proved this morning that there was a U-Haul truck there
Yes.
and that the deputies arrived
Yes.
and that there was a homicide.
Yes.
Okay. Now, you mentioned that often the practice is when you respond to a homicide, it takes some time to conduct an investigation to determine if there's criminality.
Absolutely.
Okay, so in other words, you don't come upon a homicide and determine as soon as you see a dead body, it's murder.
Correct.
Okay. If I wanted a job in your unit that you supervise and I felt all homicides are murders.
Objection,
Fair question, Your Honor.
objection, pre-trial ruling.
Sustained.
Well, you just did a lot of bad things too, lady.
You mentioned that the arrest of Miss
She needs to stop with the
Benefield.
faces.
Well, let me start
Yeah.
from, I think you told us she was in the back of the squad car.
Yes, sir.
She was in handcuffs.
Yes.
And this is a squad car with the doors that you can't open from the inside and the back, correct?
That's correct.
With a cage.
Yes.
So she's in the back of the squad car, in handcuffs behind her back,
Yes.
in a car with a cage, and you can't open the doors, but she wasn't under arrest.
No, she wasn't charged with anything.
Okay,
She was detained.
so I think you told us that the reason for her being arrested approximately 6 weeks later, I think, was so that the investigation could be conducted.
Correct.
Because you had to determine if there was criminality.
Correct.
Okay. Could have been a homicide that was self-defense.
Could have been. That was the claim.
That's the whole point of the investigation.
Absolutely.
And that kind of an investigation, understandably, takes time
It does.
and patience
Yes.
and professionalism
Yes.
and knowledge and experience.
Yes.
Do you know how old Lieutenant Alicia Byers is?
I don't.
Do you recall meeting her?
I do.
Approximately, give us your best shot.
I mean, I would guess in her 40s to 50s.
All right. Was she a young woman?
No.
She was pretty exhausted that day, wasn't she?
She appeared to be. There was a lot going on.
Yeah. Would it be a fair statement, Lieutenant? You seem like a pretty straight guy. Was she emotionally distraught?
Yes, there's a lot of emotions going on there. Yes.
In fact, her first thought upon coming back from the park with the daughter and seeing the
Objection.
cars was
Hearsay.
that her daughter was
Please
dead.
stop talking.
Oh, she hates him.
She does hate him.
Unless you'd like to make an argument for an exception, then you can approach.
He likes to
Rest
push
just
boundaries
side.
off.
Well, if you'd like to approach,
It's all right, Your Honor.
No, God in heaven.
I think, Lieutenant, excuse me, you told us that you went into the residence after crime scene had completed their portion of the investigation.
Yes, sir.
And do you recall crime scene was there before or after EMS?
A crime scene comes after EMS. The sanctity of life always comes first.
All right. So EMS was there first, and you were there, so you know they dragged Mr. Benefield out of the home from
Yes.
the bedroom.
Yes.
So when you told us that crime scene was there to preserve the scene, can we agree, Lieutenant, that what crime scene preserved was the scene following the EMS people not only working on him in that bedroom, but moving?
Yes. As always, that we preserve the scene after we attempt to save the life.
Okay. And so those crime scene photos show us, for example, what that scene looked like when crime scene took the photograph.
That is correct.
It doesn't show us what the scene looked like when EMS was running around doing what they do.
That's not possible. No, that's correct.
Okay. And that would have included the initial deputies on the scene as well.
That's
God
correct.
bless you. Give me just a moment, Your Honor.
yes, sir.
Well, there was that surprise snow, and the wind was blowing. It's really hard to conserve it, and you had been through it with leaf blowers, so it doesn't matter. Yeah, but McPherson is right. It does mean thick man in German.
Thank you,
Come on.
Lieutenant. Appreciate your candor.
Thank you, sir.
Redirect.
No.
Can this witness be released?
Yes.
Mr. Taylor, can this witness be released
Yes,
from the
sir.
subpoena? Sir, you release your subpoena for you.
Yes, sir. Thank you very much.
Okay.
And now we're going to get those witnesses in who's going to accidentally talk a lot about the CPS cases. Yeah. And the attorney knows what he's doing. That's why he kept talking. It's kind of like Alan Jackson, who also talked over objections. Because again, it has nothing to do with the law. It has everything to do with what you can put in the head of the jury. Yeah, that's why I like him sometimes and I dislike him a lot of times, because I think he's got the right strategy to help his client, but he just seemed confused sometimes.
Yeah.
All right, members of the jury, we're going to go ahead and take our mid-morning break right now. So you can step back into the jury room. Please close your notes, leave them right where they are. It should be 10 or 15 minutes. Stretch your legs, get something to drink back there, use the facilities. Please don't begin discussions amongst yourself. You are
I
free to
wonder if
still use
anybody
your
brought a
cell phones
cooler.
to send, receive text
Yeah,
messages, calls,
and a
anything like
George
that.
Foreman grill.
But please,
And a George Foreman
outside
grill.
of this group, and don't do any research on the people.
I want to have
or legal topics we've heard anything about.
the only man on the
Thank you.
jury with that's the grill master sitting there with a panini grill saying, "What do you want, honey? Sausages? I'll make you a sausage."
I know. Because the judge yesterday was funny. Hey, can you bring coolers in here? Or like, can they really? Like mini fridges, some
All right, y'all
snacks?
can have a seat. We'll be on recess. Bless you, 10 minutes.
Well, that was a fast recess.
Sorry, I was just thinking about the coolers and the grill.
Imagine they turn it into a full-blown tailgate party. You have three frat boys in the back chugging, and someone playing volleyball, and let's make it fun today. It's Friday. Let's make it
It's
shorts
Friday.
and sandals in court.
Oh, casual Friday.
Yeah. If you want to let the beer gut out, you let the beer gut out. It's Florida. You know how we roll. Well, we watched the Treehouse murder case. They had their best Sunday wife beaters on when they went to court.
Oh my God, they did. Also, that reptile trial that Mo did. Those.
Oh, yeah. Oh.
When that guy
that was-
walked in with some track pants on, like a button-down shirt. I almost lost it.
Well, I'm going to do a poll now. And again, Molly, du må godt være der. I'm going to do a poll. Remember, try not to put in your head what you had before you watched it. Try to, if you can, say what have been proven so far. And then what would you, I don't know, it's hard to take out because you read stuff online and you watched our wonderful coverage. But I don't think they are moving the needle enough if they're going to end tomorrow.
No.
It's because, again, we always have to have her start with not guilty. And then go back. And yeah, I just don't. I haven't heard anything saying that she couldn't have been afraid of her life.
Well, yeah.
Yeah.
In that moment, you have to think, was she in fear of her life? And if he's been, violent before, which we have evidence that he has.
Well, at least he has some temper because he did
Yeah.
take a pop in the ceiling.
And punch some holes in the walls.
Yeah. Well, the poll's up, so you can do it. Yeah, but again, try and weigh it on the scale of what has been proven in court right now. And and again, we don't have to think about if she pulled the trigger. We know she pulled the trigger. That's not in dispute. We know she did that because she admitted to doing that. But the state have to prove she didn't have a legal reason to pull the trigger. And
Yeah.
And I'm having a hard time with this because now also the thing, they're not moving to Maryland together.
Mm-hmm. Well, I think finding out he filed for divorce was kind of shocking to me too.
Yeah.
Because, like, Okay. It's not like she was going forth with all this stuff. But
Yeah, she was
they're
moving
also
on.
saying this was a whole premeditated thing. And that's what I'm not seeing in any of the state's evidence. They're not showing me that she planned this all out.
Yeah, are they trying to imply with the mother that she did concealed carry training and that made her do it? That's the premeditation? Because so far the premeditation, they are trying to hinge that on that she knew how
Yeah.
to use a pew pew and that
Yeah.
that her mom was at a park.
Yeah. Yeah. Because I mean, that's
Um,
all they asked.
yeah.
And then they asked, did she tell you anything? And I think they wanted to imply that too. Like, I don't know. Because like everybody is saying, I don't believe that she didn't tell her mom or therapist what happened.
No,
But
but the
it doesn't
way
make it weird. No.
but the way they are trying to prove it is by saying, well, she shut up.
Yeah.
As
She shut up.
if,
So
go on YouTube right now. There's probably 7 channels covering that. Go into their chat and say, should I talk to police? If any of them says, yeah, always, they're your friends, come back to us, because you shouldn't watch trials with them. They had proven
yeah, I
that
think,
the victim had anger issues and had propensity for violence, and that they haven't proven she was a gold digger who planned this. It's the planning part I'm missing.
me too.
I
I'm not seeing
don't
what
like
they're trying to throw out there.
I don't like the leg wound. I don't like the leg wound. I have to say that.
Yeah. But there really could be a reason to it. Who knows? Because we don't know. I mean, I don't know. Well, they're trying to say too, like she shot multiple times, so that means, well, if you're in a crazy situation like that, maybe you pull the trigger more than you think, you know?
You don't think about it.
Yeah.
But that's always the state's position. Why didn't you just do it once? Well, because the first one went into the floor. Why didn't you do it twice? That's the one that went through the bathroom wall. Why didn't you only do it 3 times? Well, that's the one that hit him in the leg. I didn't think that would stop him. It's
Hmm.
And do you know how fast even I can click 4 times? This dude wasn't rich. He had to sell his stock futures to get the ballet school up and running, and that went bankrupt in 3 months.
And that was
So he
only
had
100
nothing.
grand. So that
Yeah,
wasn't, I mean, I know that's a lot of money, but it's really not a lot of money.
it's
You're
not
like,
enough. It's not enough to persuade me that she was the gold digging type.
yeah.
A heated custody battle would have maybe, but it seemed like they were agreeing to withdraw the divorce and the charges against him as well. Um, so uh, the and I know they don't have to prove motive, but I just have a hard time figuring out what the motive should be.
Hmm.
Um, there's no evidence of the poisoning. We know that from a child custody hearing that the judge, we heard that in one of the in the stand your ground hearing, she's found no credible evidence of the allegations against Doc. But that hasn't been put into this case, so that's why you can't really use that to weigh the evidence in this case. That's why I'm saying try
Yeah.
and use the evidence provided in this 2-day trial we've been watching so far, because what you read in the papers might not be true. Just go again. I know a lot of us has that common care and read thing. Go and read what people are saying in papers about her. It's not always the truth. Go on YouTube. See, I just saw someone today claiming that TMC, because they made a program about her yesterday that was, yeah, she was probably set up. So now Karen Reed paid off TMC. She still haven't paid me off, and I've been called a money grabbing grifter, and I still didn't get my check. I feel left out.
Hmm.
Probably he Uh,
I mean,
but again, have they proven that?
yeah.
Other than the daughter said, yeah, she kept asking for things and he just sat there. But most men do that. Even us who's not stupid enough to find a really young girl, will just say, "Of course, honey," because a lot of times that makes problems go away. Because most of it might just be, I need to vent something, and I don't need your solution. I just need your, okay, yeah, I can see that. Of course.
Right.
Yeah, I'm gonna sue the Free Can Read team. I want $1 million. I just have to go check where Molly is because she's been quiet for too long.
Oh Lord. Yeah, like the number of shots for me don't really matter because I mean I've shot a pew pew before and I know how, you know, I don't know, in my opinion, I feel like it's really easy, especially if you're in a really crazy situation and you're scared. But I don't know. I don't get the gold digging stuff yet. I haven't seen anything. He really didn't have any money. And I don't see why you plot this whole, I mean, I know people do it all the time. But
Yeah,
plotting to
that's
like,
the thing we can't figure out is human nature, because how many trials have we covered where we're sitting there thinking, why the F did you do that? That's just stupid.
yeah,
Why
why didn't
didn't
you
you
just
turn
like,
around? Why didn't you walk away?
well, everybody has their whole like, if I'm in this situation, this is what I would do. But then you don't know until you're actually in the situation.
Yeah.
So,
Yeah, Aussie Insiders they claim she's lying about she did a fundraiser. Well, her child did a fundraiser for her because she got scammed by some constructor. Now they're claiming, well, she's just misusing John O'Keefe's name to raise funds for her house and scamming people. Again, the vitriol from the other side, I just don't get the hatred that people have for
yeah,
everyone. And again, I
we don't all have to agree.
no, and we don't agree in this chat about this case either, because we are
No,
grown-ups. We can hold the position that I don't agree with you on this point. That
Mhm.
doesn't mean I have to hate you and want to destroy everything in your life. I don't get how you can get this involved in someone else's life that you want to destroy. And let's be honest, it has nothing to do with Karen Reed. We all know that. But they just want to hate because they have nothing else in life. And I buy a dog. Well, they can't even keep their kids, so maybe don't buy a dog. Take a walk.
yeah, I agree.
He respectfully disagree. Never be respectful to Jamie. She will use you.
Yeah, it's okay, Dee. I mean, we're not always going to agree. We might watch trials together and be on the same page, and sometimes we might not.
Yeah.
It's okay.
Yeah.
I like to hear all sides because I mean, sometimes people see things differently than each other, and somebody gives you a perspective, and you're like, okay, I can see that.
Hold on a second. Folks, I need the audience to sit down and take your seats, please. We need to get started.
It comes in so hot every time. Yeah, Boosh came into the Karen Reed trial and was persuaded during the argument. And we do that a lot of times because I thought this case was sus, that she probably was a gold-digging youngster. But there was no gold to dig. And then
Yeah, I don't see it.
we had the desk pop and stuff like that. So that's a handsome fella in the background. Oh, I should put it on screen when I'm pointing at this handsome fella in the background. She has a tiny face. Is it just me or her face very small?
All right, welcome back, members of the jury. Hopefully no one started
She's like a
deliberations
small
amongst
lady.
yourselves, talk with anybody outside the jury about the case, did any research on the people, places, things, or legal topics we've heard anything about?
No, sir.
No? All right. State, call your next witness.
State called Stephanie Murphy.
Yes.
Well, he got called to that event in, I think it was at Mar-a-Lago, actually, because he was a contributor to the Republican Party, where she was campaign worker, a campaign worker. But he could have given off the, I have things that I don't have because maybe it's the business paying for it, but then it's up to the state to tell, because we're just sitting here and making up scenarios. We haven't heard about them.
Mm-hmm.
And she is petite. Stephen, you could be wed by within 2 weeks. It's I'm so sorry that I didn't get my wedding license when I was in city council, so I could have wed you. You would have had to fly to Denmark. But
I thought you were saying wet. You wed? Okay.
that's racist. Yeah, pocket size, yes, petite. I know EPMD, but normally you will have, even with Lally, you had a kind of this direction he was going in, put in there by his opening statement. He changed that 3 times during the case, but don't matter. But their opening statement was she wanted the kid alone. You get a divorce for that and a restraining order if he's abusive, and then you have the kid alone. Yes, Stephen. That's the problem.
Hello, ma'am. My name is Judge White. I'm going to be presiding over the case. Get yourself about 12 to 15 inches from the microphone. It does adjust up, down, left, right. Just make yourself comfortable. Will you speak directly into the microphone with a loud, clear voice? We'll hear everything.
Thank you.
Thank you.
Good morning.
Good morning.
Please state your name.
Stephanie Murphy.
How do you spell first and last name?
Stephanie is Stephanie. Murphy is Murphy.
And what is your profession?
I'm an attorney.
How long have you been an attorney?
This is my 23rd year as an attorney and actually in the Sarasota, Bradenton area.
She's
And
a
are
divorce
you with
lawyer.
a firm, sole practitioner? What do you do?
My husband and I have our own firm, and I've had that firm for 16 and a half, 17 years. Before that, I was at a larger firm in Sarasota.
And what is your topic of law that you practice?
I practice family law, which is generally comprised of divorce, custody cases, or what used to be called custody cases, and adoption cases.
Okay. I want to ask you about Doug Benefield. Did he hire you?
He did.
And approximately when did he hire you?
He hired me in March 2018. He came for a first consultation on the 13th. He hired me on the 14th of March 2018.
And what was the purpose of your duties to begin with?
Initially, the purpose of hiring me was to draft a letter to Ashley Benefield, who was pregnant with their child at the time, which I did. I drafted a letter and sent it the day after I was retained. But the purpose of that letter was actually just to initiate.
Relevance. She stated that she sent the letter, that she was retained to send the letter. Now going to explain something.
Okay, overruled.
What was the purpose of the letter?
The purpose of the
It's like
letter
a
was to open the door for discussion about Doug's participation in the upcoming birth of their child. but also to advise that if she did not feel comfortable with him being present at the birth, he was respecting her need for space.
And when did you send that letter?
I sent that letter on March 15th at 9:59 in the morning by email to Ms. Benefield.
Okay. And did you receive a response to that letter?
I did not receive a response directly from Ms. Benefield. She checked herself into Tampa General the next day to start induction.
Sustained.
So when was the child born?
Well, the child was born early. She was born on March 19th, I believe, is when she was finally born.
I don't get that induction either. That's
I
weird
don't
to me.
either, because that, if she's that early, I've never heard of that in my life. That the
No,
doctor
and
did.
a lawyer
Oh,
would not a lawyer, a doctor would have to sign off that I'm going to induce you that early.
I mean, anybody in chat knows for real, but I've never heard of that in my life.
No.
And you said early, how many weeks early was that?
Well, the child was originally scheduled, or her due date was April 8th. So I think
Sustained.
So you said you never received a response
not from Ms. Benefield.
from Ms. Benefield about the letter.
Correct.
And to your knowledge, did Doug ever receive a response to that
To
letter?
my knowledge, he did not receive any response from Ms. Benefield or anyone on her behalf.
And I think you might have said this, but the child was born on what day?
She was born on the 19th of March.
And at the time the child was born, did you or Doug know that the child was born?
No, gosh, we didn't know for a good 5 or 6 weeks after she was born.
Okay. And how did you find out that the child was born?
I actually found out because I had been monitoring the docket for Manatee County court system, just because there had been no response. And so on May 6th, I saw that Ms. Benefield had filed a petition for protection against domestic violence on, I think it was April 23rd. So about 2 weeks prior to me finding out, she had filed the petition. And in that filing, there was, she identified the birth date of the child, as well as I think the child's name, which is the first time we learned about that too.
Okay. And you said she filed a petition for, what did you call it?
It's a petition for protection against domestic violence. So it's an injunction. A lot of people refer to it as a restraining order, but it wasn't granted as an injunction at the time.
Okay. So when, just for knowledge of people that may not know, when someone does a request for an injunction, what is sort of the procedure that it needs to go through?
Yes, I know that, but it sounded like she wanted then, when we heard this during one of the pretrial hearings as well. And it sounded like she just went to the hospital and said, hey, can you pop out my baby? I get it. If there's a medical risk, yes, you can induce a labor. I told that in Switzerland, they go by the weight of the baby. So if you are within the last couple of weeks and the baby have reached a certain size, they will induce your labor to make it easier to give birth. So the baby doesn't, because bigger babies make for bigger complications. So I could understand that, but then let's have that in the record.
Exactly. And everyone, we want to make this clear. They're saying, like Baker's saying, they're making it sound like she just was like, oh, I'm going to go up there and see if they'll just take care of it. Like there was nothing about a medical issue or anything, which that's very understandable.
Yeah, but in Switzerland, you can get, I believe, two weeks earlier, maybe 3. I'm not sure. But again, the state makes it sound like she just she was driving around and thought, nah, I want to have a baby today, and you can't do that without a medical professional signing off on it, and that's why that doesn't make sense to me. That she just, I'm gonna pop out a baby a month before.
Yeah. And you guys are right. Maybe she lied about the due date or something.
Yeah, but that
really
should
wasn't
be
that case.
that should be on the file somewhere. But I could also see, because she is petite, that there could be complication if the baby got too big.
Mhm.
I don't know.
Yeah.
I'm so sorry. My pause game is always the least flattering on the planet.
So a person who files a petition for an injunction, they file it at the courthouse in the clerk's office, and then that gets sent out to the judge, usually a family law judge who's just in charge of injunctions that day. And then the judge has three options, I believe. One is just to deny it completely. The second option is to grant a temporary injunction, but then there's a follow-up or a return hearing.
I'll overrule.
And then the third option is what happened in this particular case, is that the judge denied the petition as a temporary injunction. So there wasn't enough evidence in the petition to warrant a temporary injunction, but a hearing was set to review it.
Okay. And when was that hearing set approximately, to your knowledge?
I believe it was originally set for May 8th, but Ms. Benefield made a request to continue that hearing.
Okay, so it was then continued?
It was.
Before the hearing actually happened, did you file any documents on Doug's behalf?
I did. So, well, of course, I filed a notice of appearance in that injunction case. And then we started an entirely separate case. So I filed on Doug's behalf a petition for a parenting plan unconnected with divorce. So he wanted to establish a parenting plan so that he had really time sharing and decision making for his daughter, because he had none of that up to that point because she was withholding all that information.
And some of the lingo may be familiar to us, but so time sharing, what is that?
I'm sorry. So time sharing is what lay people and a lot of people used to generally call visitation. So it used to have custody, parent had custody, and then another parent had visitation. That was changed, and now in Florida at least, and especially in our circuit, we have parenting plans, which is a comprehensive agreement or an order by the court that lays out all the details of parenting as a not intact family. So the major components are decision making and time sharing schedule. So how often the child spends with each parent.
And you said not connected with a divorce proceeding?
Right.
So I would assume that means it can either be with a divorce proceeding or without.
It can be. And of course, it can be also in a paternity case. So parents don't have to be married. But in this case, because they were married, Doug was not initially pursuing a divorce because he hadn't had any contact with Ms. Benefield for a while. His initial...
Sustained.
Okay. So initially it was not connected with divorce.
Right. His priority was his daughter.
And you mentioned the injunction case and then your motions. Were they two different case numbers?
They were two different case numbers. So the injunction case number was 2018 DR 1823. And then the new case that I filed for Doug was 2018 DR 2318. Now, they're companion cases, though, so they might be separate cases, but they travel together as companion cases, and they're assigned to the same judge through this unified family court program.
So when the hearing was set and ultimately heard, were both of those case numbers heard?
Both of the case numbers were heard, but it wasn't the...
He's dead.
What?
Jill asks how she's getting around attorney-client privilege. He's dead. He can't assert his privilege. So that's easy.
Well, you just came out and said he's dead. It's like,
Well,
wait,
I pulled
what?
it up.
I did see it.
Our first pleading wasn't the same pleading that was
8 years older.
heard at the time of the injunction.
Yeah, but if in a murder trial, I think they allowed that the client attorney privilege thing is also, there's some rules about it in murder trials. They, like doctors and stuff like that, can testify about certain stuff. My pause game is on point today, Jamie.
It really is.
I'm doing it good. I think, yeah, technically, but Jess, who knows a little bit about the law, I believe in murder cases and stuff like that, there is some, there are some things that can be talked about. It's not in question, so I don't think so.
It's narrative, non-responsive to the question.
Sustained.
So what generally were the allegations in the injunction petition?
Generally, Ms. Benefield was alleging that Doug had been violent toward her. She alleged that he, I think, had hit the dog, fired a gun into the ceiling. The biggest allegation was that he was poisoning her and their child in utero with heavy metals.
Okay. When was this hearing finally held?
The hearing was held in two parts, actually. It was July 30th, and then the second part was September 17th.
Not responsive to the question.
Overruled.
And that was the year 2018, correct?
Yes, it was.
Okay. And what judge was this in front of?
It was in front of Diana Moreland.
Okay. And you said it was held on 2 days. Why was it held on 2 different days?
It took a very long time. So we had, both
Thank you,
sides had
Dee.
experts, toxicologists, and we had a number of other witnesses appearing. We had,
Not responsive to the question.
Overruled.
there were also people from the child protective team testifying. And so there were too many hours, and so we couldn't squeeze it all into one day.
Okay. And ultimately, at the end of this, did Judge Moreland make a decision?
At the end of that, she did. There
I'm
were
sorry.
other decisions along the way, but ultimately she made a decision on the two matters that were set as the companion cases.
And
Yes, and in that hearing, no evidence was found of heavy metal poisoning, but she did buy what's it called, trykkammer, pressure chamber treatments to get it out of the system of both her and the daughter. But there's no evidence that she had ever been poisoned. She claims he bought her tea, and that was a poisoning, but there's no evidence of that.
I meant was on the second hearing day, did she make a decision?
Yes, she
Okay.
did. September 17th.
And what was that decision?
There were two parts because, there was two cases.
Objection, Your Honor, just final decision.
Barometric, yes.
For the prior motion.
Hyperbaric,
Yeah.
yes.
Overruled.
Okay,
Go ahead.
thank you. For the injunction, she made a lot of rulings and a lot of findings about lack of evidence and then denied
We don't
the
want to,
petition.
we don't want to talk about
Oh.
what went into that. We just want to know what her ruling was.
Okay, she denied the injunction. So
Okay.
that was the first part.
Okay. And then the second part,
The second part was on the parenting plan case, the time sharing case. And so in that, she entered a ruling for a time sharing schedule. That would be an introduction schedule because Doug at that point had never met his daughter, and that would increase over time on a temporary basis. And then she entered a ruling that he would have ultimate decision-making authority over the child's medical needs and otherwise shared decision-making.
Overruled.
and otherwise, I'm sorry.
Otherwise shared parental responsibility, which is joint decision-making.
Okay. And as of that day, was Judge Moreland's ruling timed? Like, was it immediate? Was it in the future for the time sharing?
It was immediate. Well, not that day, but she said the first day, and it was just a couple of days later, the 21st, which is when Doug was supposed to meet his daughter for the first time.
Okay. And this time that Doug met his daughter for the first time, were you present?
I was, yes.
And where did this happen?
It happened at Manatee County Sheriff's Department on, I think it's 301.
Did you arrive together or separate with Doug?
Oh, we arrived separately. When I got there, Doug was already there.
And how old approximately was the baby at the time?
I think she was around 6 months old. She was born in March, and this was then the 21st of September. It's about 6 months.
And can you explain how that interaction went? Did you observe it, first of all?
I did.
Okay, how
So
did
when
it-
I arrived, I got into Doug's truck and we just waited because we were there early. And then he saw Ashley arrive with the baby. And so he pulled the truck closer, and then we both got out of the car and started walking toward Ashley. And then it was just an odd kind of interaction, actually. She turned to me with just this nasty look on her face and said
Oh
to
my
Doug,
God.
Yeah,
I'll
this
sustain
this
that from the
is
characterization.
She turned to Doug and said, "Are you dating her?" Just like, and so obviously we both said, "Well, of course not, no." And then I hung back, and Doug then was standing there, and Ashley approached him with Emerson, and they started talking. Eventually, she let him hold the baby, and they just kept talking for a few minutes. Then I was advised that they were going to be leaving together, strangely, that Ashley was going to be going with them for the time sharing.
Was this a surprise to you?
Absolutely. We had just been in knockdown, drag out litigation for months with just her.
why do you need to put on all those knockdown, drug out, blah blah blah?
I know.
You don't need to say
I
that.
don't like it.
You had been in litigations and blah blah blah. You don't have to put
Yeah.
all those extra words on it.
You don't.
And she's an attorney. She knows what she's saying.
Horrendous allegations that were unfounded, and yet
Thank you.
she said, "I want to go with you," and he said, "Okay."
Objection to the characterization of the allegations being unfounded and continued editorializing by this witness.
Can we approve?
Sustained.
Yeah, go tell her you're a lawyer. You know what you're doing. Please stop making stories. Yeah,
Yeah.
she does sound catty.
What is this when it's like people? Oh, anyways.
And again, what's that smile? She
So
was your
when
client. You don't have.
They told you they were going together. What was your response?
I pulled Doug aside and I cautioned him about going with her. I advised, his attorney, and so I did advise him. I said, "This isn't a good idea. She's trying to set you up for something. Don't do this." And he said, "I understand. I'm going to go ahead and do it anyway." And so I stayed and observed as Ashley strapped the car seat into the back of the truck, and she got in the truck with Doug, and then they left together for his first time sharing with his baby.
Okay.
For their baby.
So after this first time sharing, did this seem to start a time of peace, so to speak?
It was a time of peace. Actually, before the 26th, but on the 26th, Doug and Ashley both signed a stipulation that I had drafted at Doug's request, which expanded the time sharing that Judge Moreland had ordered at the hearing on the 17th. So within a week, they had already agreed that he was going to have even more time sharing than Judge Moreland had said.
Okay.
And so that was filed in the court file. It took away the restriction of meeting at the sheriff's office if they chose.
Non-responsive.
Ooh.
So yes, that was the beginning of a time of peace that extended for quite a period of time.
And during this time, well, how long did that last, the peace?
It lasted, to my knowledge, about 11 months.
Okay. And during this 11 months, did you see Doug and Ashley?
I saw them in magazines. Actually, they were attending gala events together, and so they were kind of
Speculative, and hearsay.
Ooh.
so other
Leah.
than seeing them together at the sheriff's office, I didn't personally observe them out in public, but I did. Like I said, I saw them in various forms of media. They're quite the couple.
Okay. And you said this peace lasted about 11 months. What broke this peace to your knowledge?
Well, it was my understanding from Doug that they were getting ready to move in.
Hearsay.
Let's not talk about what happened with what Doug said was supposed to happen. But during this time, did Ashley stop speaking to him?
I'm sorry, I didn't hear your question.
During this time, did Ashley stop speaking to Doug?
Objection. How would you know it calls for hearsay?
Effect on the listener.
Ooh.
Thank you. They continuously spoke to one another for 11 months until August 16th of 2019.
Objection. I thought that was a yes or no question. Objection, non-responsive.
Sustained.
Okay. So around this time, you said November 16th?
August 16th
August 16th.
of 2019.
Okay. What happened at this time?
Doug was supposed to be moving in with
Hey, Elizabeth Myers. This is the first witness with any goods to it today. We had the mom, we had her former shrink, we had a police officer. They couldn't really tell you much. The state has been trying to imply that by having a lawyer, you are guilty. This one is Doc's divorce lawyer, and she really, really want to narrate her answers. Too much to my liking.
Ashley and her mother, Alicia. He had moved all these things and
And we're not going to talk about the specifics of that.
Counsel, I'm sorry to interrupt. Director, I request the instruction from the court about,
Can we not do speaking objections?
Do you need to approach?
Oh boy. Yeah, she's driving me crazy. You can just tell when people are on the stand and they just want to try to get every little thing in that they can, and I don't like that. Like,
I can't stand up for 2 seconds. There's a new sidebar.
you know,
Yeah, this lawyer is very unprofessional to me. I don't know if it's just me, but
well, she's just trying to get all these little things in there, and I don't like that one.
Tim Swoop
Yeah.
loves her.
Oh, I mean, cool.
Yeah. As we
I
talked
mean,
about
she
earlier.
seems very invested in his case, clearly,
Yeah.
and that's good.
And
But
I have a problem with that. I saw them out and about. They were quite a couple. That's a weird statement to come by.
Members of the jury, this is one of those situations that's going to take us a few minutes, so I'm going to excuse you back to the jury room. Again, please don't begin deliberations amongst yourselves. Please don't contact or speak with anyone outside the jury about this case. Don't do any research on the legal things, legal topics. Before you think about it, certainly you can use your phones and everything else to communicate with us. Thank you.
We need some Fifth Amendment.
All right, the jury's out. Go ahead and see. This point, I'm going to excuse you from the courtroom so we can have our hearing. Ma'am, the rule of sequestration has been invoked. You're not to discuss your testimony or the questions that have been asked with anyone, including the attorneys, any other witnesses, any third parties. You're not to talk with other witnesses about questions they were asked, the testimony they provided.
Could
It's my
be.
understanding this may be on the internet somehow, so you're not supposed to watch
I don't know, Sue.
anything at all that's
It
happening
could
within these
be.
4 walls.
Yeah,
Thank
we
you.
are a little behind. That's why we're on fast forward.
could be, and it could be. I mean, you're only hearing one side of the story, so I don't know.
Yeah, Ruthie, we talked about that yesterday, and someone asked me in my comments. I think her lawyer have said she should look
All
like
right, the
that.
witness is out of the courtroom. Do you have,
Judge, I don't have a specific instruction. We may need to craft one, but what I'm looking for so that the court knows is instruction to the jurors that these hearsay statements that have been repeated by the witness thus far, and for purposes of the remainder of her testimony, the other statements she will undoubtedly try to get out are not being offered for the truth of the matter, but rather being offered for whatever reason that the court wants to ascribe to provide the context to her narrative in response to the question.
She is out on bail, so she has access
so
to
as I
makeup.
said, go ahead. Do you want to
Yeah.
No.
So as I said, I'm not aware of a standard jury instruction in the 2.1 to whatever it is, 2.8 range or 2.9 range that does that very thing. So I want to give the parties the opportunity with the jury not present to look and see if there's a standard jury instruction.
I don't think
I can give it. Like I said, I drafted one for a prior homicide trial where there were a number of statements that were admitted by me, by the decedent, where there were objections, just like we're having now, numerous objections to hearsay.
Yes.
But obviously, none of them were being offered by the state for the truth of the matter asserted. That's what was argued, and I made that finding. So in order to have just a blanket instruction, I crafted the following, and the parties ratified it. So I gave it specific to the decedent's statements in that case to, it was either an attorney or some sort of financial planner about some final wishes. And here's what it says. You are about to hear statements made by declarant, and I put the name in. These statements are relevant only to explain the reaction and responses that they elicit. that is the effect those statements had on a reader or a listener, because there was also a letter that was involved. You are not to consider the statements by declarant's name as true, but only to establish the context of readers or listeners' actions, reactions, and responses.
That'll be fine, Your Honor.
Except for that you are about to hear me, because they've already heard some, so.
So the court want to substitute, you've already heard and may continue to hear. And by suggesting that, I'm not suggesting that I agree to the further admission of hearsay or her interpretation. That's not directly responsive to the question.
So reserving on other objections. And certainly there may be objections you have as we go where you think that they are not being offered for the effect on the listener and that it's hearsay without exception. So those still may come up. All right, so when we bring the jury back in, you want me to give that instruction?
Please.
You have heard and may continue to hear statements made by Doug Benefield to Stephanie Murphy. These statements are relevant only to explain the reactions and responses that they elicit. That is the effect those statements had on Ms. Murphy.
If I may, Your Honor?
Yes.
I would suggest that it just name Stephanie Murphy, not Doug Benefield, because I think in her testimony it's been broader than that. So I think by identifying the instruction as it relates to this witness, the jurors will consider the testimony appropriate.
All right, so let me go through this again because I have declarant and recipient, reader or listener. So you have to tell me where you're talking about.
Sure.
You are about to hear statements made by Doug Benefield.
Yeah.
These statements are relevant only to explain the reactions and responses that they elicited. That is the effect those statements had on Ms. Murphy. You are not to consider the statements made by Doug Benefield as true, but only to establish the context of Stephanie Murphy's actions, reactions, and responses.
Okay, so here's my concern. For example, Ms. Murphy also testified about Judge Moreland, about a couple of the medical records and things like that. And I would prefer, and I think the fairest interpretation would be, ladies and gentlemen, Stephanie Murphy has previously said and may continue to refer to out-of-court statements. You are instructed that these statements, if and when made, are not, you should not consider them for the truth of the matter asserted, but rather for context as it relates to Stephanie Murphy's testimony. That's how I think appropriately it should read, Your Honor.
Response?
Judge, I think these things that he's talking about were objected to and they were stopped. So I don't know that it's better to highlight it anyway, but I don't know if adding names in of people to fit this, statements of Doug Benefield, this person, that person, this person, I don't know that would be effective to the jury. So I'm a little confused about how to handle it.
All right. Any final thoughts?
No.
All right. I'm open to giving limiting instructions, curative instructions that are suggested by the parties. However, the most recent one proposed by the defense, I don't think is legally accurate. It would be telling the jury to disregard testimony and evidence that's already been presented. I thought the request from the defense, because the objection came specific to Doug Benefield was supposed to move in with the defendant, and that's where we stopped. So it was my understanding that the instruction that was requested was specific to any statements made by Doug Benefield to Stephanie Murphy, that those are only relevant to explain the subsequent actions and effect that those statements had on Ms. Murphy, and telling the jury not to consider the statements by Doug Benefield as true, but only to establish the context of Ms. Murphy's subsequent actions, reactions, and responses. I don't think the limiting instruction proposed by the defense is the correct one to give. So I'm open to considering language that we can talk about some more, but no, the one you just said I don't think is appropriate.
All right, well, the message that we're trying to give the jurors is that when this witness makes hearsay statements, that the jurors should not necessarily receive that information as true, that it is being offered rather not for the truth, but to show the effect that it had on this witness. After all, that's what this.
Well, she comes on cam when she wants to come on cam. She's a prima donna. She's kind of like Jamie.
Yeah, that's true.
So she'll probably, right now she's sleeping in front of the door because it's a little hot out. So she's just sleeping. She's a cutie. Hey, Ernie Birdie.
Witness is testifying to. She did not limit it just to what Doug told her, Judge. She's referred several times to what she heard from Ashley. She's referred to medical records and to allegations. She's also referred to Judge Moreland's decisions. She's expanded upon them. She's incorporated hearsay into her testimony. This was why I approached the bench before she took the stand. So I anticipated this. That's the way she's conducted herself in the deposition and in all of her prior statements. So what I want, respectfully, Your Honor, on behalf of Ms. Benefield, what I want the jurors to understand is that as it relates to Ms. Murphy's characterizations based on hearsay, that they should not receive it for the truth of the matter asserted. Rather, they should receive it to show the impact that it had on Ms. Murphy.
Response.
Judge, first of all, anything that Ms. Benefield said is not hearsay, so it does not qualify under any of this analysis. I do not believe she said anything about medical records. I may be wrong. She did start to mention that she checked herself into the hospital. There was an objection and she stopped speaking. So I would agree that that your idea is correct and that should be the instruction.
Final thoughts.
So everything that the defendant says is not necessarily admissible. It's not necessarily relevant. It's not necessarily an admission. For example, Judge, if during the course of all of this, Ms. Benefield may have stated how much she loved this routine of a mouse named Topo Gigio, I think we could agree that that would have no relevance. And if this witness wanted to get up and talk about that merely because that is something that Ashley Benefield repeated, that wouldn't make it acceptable. So I vehemently disagree with Ms. O'Donnell's statement that anything the defendant says is admissible. And I'm concerned about the editorializing by Ms. Murphy being interpreted by the jury as truth, as unvarnished and documented conclusions. And so I would like the jurors to know basically the definition of hearsay. I would like the court to instruct them that it's not being offered for the truth of the matter asserted. It's an exception, and it can be considered to show how this witness reacted to it. That way, Judge White, it expands the parameters wide enough that the instruction would include hearsay from any source that Ms. Murphy refers to, whether it be Ms. Benefield, whether it be Doug Benefield, whether it be the hospital records or Judge Moore.
All right, thank you very much. At this point, I don't plan on giving any sort of cautionary or limiting instruction. I haven't heard the parties agree on language. It doesn't sound like the language I've suggested is acceptable to both sides. So at that point, we'll just continue with the question, objection, ruling. Specifically as to the request regarding editorializing and characterizing, I'm going to sustain on those grounds. There's been, I think my information in front of me is that Ms. Murphy is a fact witness. All right. The request that I give the definition of hearsay to the jury is denied. As we all know, the determination of legal matters, including whether a statement is hearsay or not,
or any sort of evidence is hearsay. That's a judicial matter, not a legal. It's a legal question, not a factual question for the jury. Those are my decisions. I'll note that it is already factored into a court's ruling. If a statement is offered, if an out-of-court statement is offered to prove the truth of the matter asserted in the statement, it is hearsay. The issue then becomes, is there a recognized exception to that statement or to that hearsay? And is it relevant and material to the case? That's how I'll continue to make my decisions, subject to the objections and the arguments that are made. Are we ready to bring the jury back in?
I do have one scheduling question, if it's okay with Your Honor. We have, after Ms. Murphy, we have 2 law enforcement officers here. And then our next witnesses are Dr. Broder and Dr. Quintal. Do you feel like I'm safe in telling them they could come after lunch? That was when they were originally scheduled, but they have patients. They're asking if they need to cancel to come early.
I have no idea how long these next I don't know how long Ms. Murphy's going to take. I don't know how long the next 2 witnesses are going to take.
Well,
I have no idea.
I guess the question is, Judge, if we end at 11:30 or 11:40, are you going to want to take a lunch, or do I need to have Dr. Broder here? Because he's in with patients right now, so I need to be able to tell him. We originally thought he was after lunch.
You mean with Ms. Murphy?
We have Ms. Murphy and then 2 other witnesses we plan to do before lunch. I just want to know if I'm safe to tell the doctors they can come after lunch so they don't cancel patients.
My habit would be if we finish with witnesses around 11:45, unless that very next witness was both sides agreed it's going to be just 5 minutes, I would probably take a lunch break at that point.
Thank you. I asked it poorly. That's my question. I just want to be safe in releasing them so that, Your Honor, so we can keep moving. Or not releasing them, putting them after lunch. 1:30? Should I tell them 1:30?
It depends on when we finish
Okay.
this morning. I
I'll
don't
just
know.
tell them it's after lunch for now. Thank you, Judge.
Are you ready to bring the
It's
jury
your
back in?
job to have the witnesses there.
Defense?
It's not the judge.
All right, let's bring Ms. Murphy in first.
Yeah, both sides playing games, but I just don't like that implying that having a lawyer means you're guilty.
Yeah. Like, just because you're not running around telling your story, your side of the story, doesn't mean you're being shady.
No.
All right, Ms. Murphy, have a seat as you're settling in. Did you discuss your testimony with anyone else outside of this room?
No.
Did anybody try to approach you and discuss anything about this case?
No.
Did you watch anything or any of the proceedings?
No.
All right, ma'am, while you were outside, I did sustain 2 objections that were raised by the defense. And that is some of your testimony has been editorial rather than factual and has been characterizations of observations as opposed to observations.
Okay,
So just FYI, I did sustain those 2 objections.
okay,
Otherwise, we're just going to keep having questions and answers. I'll rule on objections as we go.
great, thank
All right.
you.
Go ahead and bring the jury in.
Well, welcome, Miss V. Yeah, and that chick over by the toilet, she's the one stealing pens.
All right, y'all can have a seat. Welcome back, everybody. Did anybody begin discussions amongst yourselves? Talk with anybody outside the jury about the case or do any research on the people, places, things, or legal topics we've heard anything about?
No, sir.
Everybody says no. All right, you may resume your question.
And I believe as we left off, Ashley and Doug were not speaking to each other,
I'm not showing my gut.
pretty much not speaking to each other.
Right, beginning on August 16th, 2019, they were not speaking to each other.
Okay, and as a result of that, did you ultimately file anything on Doug's behalf?
I ultimately did, yes.
Okay, and what was that?
We filed gosh, let me think back, it was so many years ago now, a series of things, but one of the first things that we filed was an amended petition for divorce. And so it was actually a motion for leave to amend with the amended petition attached to it, which is the procedure.
So that ultimately means it was not seeking divorce before, but now the petition is.
Yes, that's correct. And still the parenting plan with some additional allegations, but that's what the main first pleading was.
Okay. And at some point after this was filed, did you get information that there had been complaints filed against Doug Benefield?
Yes, I did. So that amended petition was filed, I think, November 6th or 5th of 2019. And then within a month, I would learn that there was a series of complaints filed with.
Object, hearsay.
I'll sustain.
Ultimately, these complaints that were filed against Mr. Benefield, were they documented or filed in any way in your casework, in your cases?
Object, relevance.
I'll overrule.
So of course, we didn't attach them as exhibits to our next pleading, but we did file an amendment.
Object, editorialize.
Sustain. That would ask for a yes or a no.
Okay.
Yeah.
Can you repeat the question for me?
Those complaints, did they make their way, the information at least, into your filings in your cases?
Yes.
Okay. At some point, did Ashley file an injunction request based on these allegations?
Yes.
Okay. And around this time, was there a psychological evaluation ordered with Dr. Broder?
It was not ordered by the court. There was a psychological evaluation that was put into place through, I believe, the Child Protective
Objection,
Team.
editorialize.
Yeah.
How many times?
She's constantly trying to tell a story.
So an evaluation was recommended.
I sustained it.
I
Hello.
requested instruction from the board to disregard the last answer.
Members of the jury, I sustained an objection. When we had our initial instructions, the preliminary instructions on Monday morning, I want to remind you one of those very important instructions. If an objection is made, you're not to guess or speculate as to why it was made. Likewise, you're not to guess or assume or speculate what the answer might have been had the objection not been sustained and the witness had been allowed to answer. So you're to disregard those last answers.
As part of this process with,
Sufficient?
I'm sorry.
Thank you. Yes, sir.
Go
Sorry.
ahead.
As part of the process of these cases in court, did Ashley and Doug Benefield, to your knowledge, see a Dr. Broder
Yes, they did.
for a psychological evaluation?
Yes.
Okay. Do you know when this petition for injunction filed by Ashley was set for a hearing?
I don't remember the date that it was initially set because she filed a motion to continue.
Objection,
Basis?
editorializing,
Yeah.
not responsive to the question.
Oh,
Oh my God, woman.
It was continued several times after she filed a motion for mediation, and then eventually it was scheduled to occur. I believe it was September 30th of 2020.
Okay. So you said it was continued several times because of a mediation. So just what is a mediation and how does that play in?
Okay, so mediation is a settlement conference that takes place. It generally involves the parties as well as their attorneys, and then a neutral person who's generally a certified family court mediator. And so what generally happens is a mediator goes back and forth between each side to try to work out an agreement. And in this case, it was ordered by Judge Moreland in response to Ms. Benefield's motion.
To do the mediation?
Correct.
Okay. And did you participate in the mediation?
I did, of course.
And also Doug and Ashley Benefield?
Yes.
And as a result of that, did some of the focus of the hearing coming up change?
In anticipation of the mediation, yes, the focus of the upcoming hearing on the 30th changed.
Okay. And in what way did that change?
Earlier in September, I think on the 17th, Doug and Ashley signed a joint motion to release the psychological evaluation reports in the divorce case, in the 2018 DR 2318 case. Because in that situation, the psychological evaluations had not been ordered by Judge Moreland. They were put into place through.
Objection, not responsive, editorializing.
I'll sustain on the narrative.
So they did a motion, joint motion to release the psychological evaluation.
Yes.
And is that fairly typical? It's needed in this realm to get that result released to the parties.
Oh, of course.
Objection, relevance, it's what's taken place in this case.
Ooh.
A judge would not just is not able to. Oh, I'm sorry, Judge. I apologize.
A judge doesn't release that report unless.
The judge orders that it can be released.
Okay. And Doug and Ashley did a joint motion for that to happen.
They did.
And to your knowledge, what was their path forward from that point?
The path that went into place was they were reconciling and moving to Maryland.
Speculation as to what the path forward was.
Ooh.
And so when we were leading up to the week that he was killed, it was agreed upon that they were going to result in an impasse of the mediation because they were reconciling. And then the hearing on the 30th, the week after, was only going to be to release a psychological evaluation report.
Okay.
And they were going to pursue the move to Maryland.
Okay. So ultimately, the only thing that was supposed to happen at this hearing on September 30th was the release of the psychological event.
That was it.
That was it. Okay. And do you recall what day of the week that was, September 30th?
I believe it was Wednesday. So the mediation was a Thursday prior to the killing. And then the hearing was supposed to be Wednesday, the 30th.
Okay.
Did you notice how she just slipped killing in there when she's constantly be calling it an incident up until now? My pause game is the best pause game on the internet. She looks like an angry Muppet.
And what day was Doug killed?
Sunday night.
And that would be the 27th?
Yes.
And who was the judge going to be at this hearing on the 30th?
Oh, it was still Diane Moreland. She was still the judge on the case.
And at all times that you dealt with Doug, did he ever seem to you overly angry or aggressive about things?
No, I thought Doug was never angry. He was very mellow and matter of fact. It was a point of contention between us, actually.
Okay. I have no further questions. Thank you.
What?
You wouldn't really know.
Yes.
He was, yes, but Brittany, she's been calling it an incident the entire way through. And then she just slips in killing. He was killed, yes. But again, it's good for the jury to hear that. And again, that he's mellow in front of her. What does that mean?
Good morning, Ms. Murphy.
Good morning, Mr. Taylor.
We've met on a few occasions, have we not?
Yes, we have.
Hey, Pete's Pony. This is his divorce lawyer. She has been very, very editorializing all day long. There's been a lot of objections, but she got to tell a story about Doc being a good guy.
We meet again this morning.
It's lovely to see you.
So your specialty is family court,
Family law, yes.
and you've been practicing.
Yeah, that am I right to understand that contention means they disagreed? So they had there was a contention between them because he wasn't angry. When I was in my divorce proceedings in court, my lawyer told me, shut the F up and sit still. Don't let them bait you into anything. So I thought it would be a good idea to be mellow-headed and level-headed and mellow in a divorce proceeding. What's the contention? Did she want him to punch a hole in the wall?
Practicing family law, I think you've told us 23 years. You have your own firm, you and your husband.
Yes.
And in that capacity in family law, correct me if I'm wrong, but when you litigate matters in family court, excuse me, there are rules and procedure that apply to family court, are there not?
In all courts, and including family court, yes.
Okay, such as the rules of evidence,
Yes,
the rules of procedure, family court procedure,
yes,
and ethical obligations as well.
that's correct.
Those always govern your behavior with respect to the tribunal, the court, correct?
All of our behavior, yes, that's correct.
Are you familiar with Florida Bar Rules of Professional
Objection,
Conduct?
relevance, Judge?
I'll overrule. I don't know where this is going, so I'll overrule for a moment.
Thank you.
I'm-
Are-
I'm familiar.
Yeah, Rule 4-3.3, candor toward the tribunal.
I'm familiar with that rule.
All right. You're familiar with that rule's obligation of a duty to disclose false evidence.
I don't have the rule in front of me, so if you want me to read and see if that's exactly in the rule, I can certainly take a look at it. I'm generally familiar with the obligation to provide candor to the court.
Yes, and to disclose if evidence is inaccurate. I think
Yes,
we can
exactly.
agree on that,
Of
correct?
course.
That would include, would it not, a failure to correct a materially false statement of fact?
Yes, I'm aware that that exists, but I don't see how that could apply to my case with Doug.
All right, well, let's see. I want to ask
Here he
you
goes.
about a sequence of events now relating to the litigation that you mentioned to us between Doug Benefield and Ashley Benefield.
Was this the injunction you're referring to or the divorce case?
I'll be very specific in my questions, if you'll be patient for a moment.
Of course.
It just takes him 10 years
Oh.
to ask them.
Mr. Lawyer Man, you've been on the planet 74 years, but when a woman looks at you like that and says, of course, tread carefully. Tread very carefully. And hide the knives in the house.
He will ask the question 84 years later. That's fine.
Ashley Benefield files her domestic violence petition on April 23rd of 2018. Is that correct?
I believe that date is correct, yes.
Just so there's no mistake. She then, correct me if I'm wrong, because you seem to have the dates mastered. Ms. Benefield then files a petition for divorce and temporary TPR on May 31st of 2018.
I don't remember the date that she filed those, but she filed, those would be, I think, separate things. And so in response to the petition for parenting plan unconnected with divorce that I filed on Doug's behalf, she filed an answer and a counter petition seeking divorce.
So your answer for purposes of my question was you don't recall the date.
Yes, that's correct.
Okay.
And it wasn't that she
May I
just.
approach the witness?
Yes.
See if this
Yeah, I really
refreshes
want
your recollection as to the date.
I need to get my reading glasses. Mr. J.
Oh, geez.
Yeah.
While you're looking at it, when I refer to the initials TPR, what does that stand for?
Termination of parental rights.
Okay.
Yes, thank you for the reminder. You're right. This is the 31st of May. And she did file a separate case. I had forgotten that.
Well, the question pending was, does that refresh your recollection as to the date?
As to the date, yes, the
Yes.
contents, no.
Was I correct in my statement to you that the date was May 31st, 2018?
Yes,
Now, would you take a look, if you need to refresh your recollection, as to count 2, specifically paragraph 5? Miss Benefield makes some allegations there, does she not?
she does.
All right. On June 19th of 18, you file Mr. Benefield's answer.
I don't remember that.
May I approach?
Yes.
Let's see if this refreshes your recollection.
Thank you.
Is the date June 19th, 2018?
Yes, that's correct.
All right. And that's your answer, is it not?
This is Doug's answer that I drafted and
Oh,
filed on his behalf.
That
Yes.
you drafted and filed on his
Yes.
behalf.
Correct.
And in response to paragraph 5 of Ms. Benefield's petition, you deny it, do you not?
Objection relevant, Judge?
Oh, I think,
I'll overrule on those
yeah,
grounds.
thank you, Judge. Ms. Murphy, my question was, if you would look at paragraph 5, do you enter a denial?
I'm sorry, it's number 5 is 7 pages long. So I was just checking to see if that was correct.
Well,
Yes,
Graham.
we denied these allegations that
Okay.
he committed those acts during pregnancy.
now, as part of that action, your client, Doug Benefield, submits to a deposition 27 days later on July 17th, 2018, does he not?
I don't remember that exact date, but he did submit to a deposition around that time frame.
Okay, and in that deposition, while,
Sustained.
Your Honor, she opened the door.
Yeah.
She's already talked about,
Would you like to approach?
yes.
Yeah, they kicked the door open. He should be allowed to ask about these things.
Oh, yeah.
Because again, if it's good for the goose, it's good for the slander. Well, you missed a lot of arguing because this lawyer really likes to talk about how she remembers everything, and then she didn't remember she filed a petition for Doug, but she remembered everything else. How Ashley's face were, how so far she has the Jen McCabe award in this trial. I'm just needing her to say, did she cry? Ashley, Ashley, Ashley.
Ugh.
He was in business, something. And I don't know what. I can't remember who was in here yesterday telling about how he was getting sued because he overpromised and underdelivered a lot. Jesus, my neighbor is mowing the lawn or something. It sounds like he's using an old Wartburg from East Germany.
Oh, what?
A Wartburg. It's a
What's
brand of car. You couldn't get it in the U.S. because it's a commie car. It's like no, you don't know what do you know what a Skoda is? A Lada?
No.
It's a really, really crappy car that all the hippies bought back in the 80s. But it was a 2-stroke engine, so every morning you could just hear all of those commies sitting outside, run, duck, 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 because it was such a bad engine.
Oh my
But
gosh.
who is now? That's the question. I don't understand the question. Well, you should have one, Sean. It was made of. Yeah, it's like a Yugo, but just worse. It could also be a Trabant. It's every morning when it just got below 5 degrees, you could just hear them all over the neighborhoods. Ruck, duck, 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 duck. Ruck, duck, 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 duck. And they had no heater, they had nothing. I don't even think, well, we got the Western imperialistic style, so I think they came with a radio. I don't believe they had a radio in the Eastern Bloc. I was, yeah. Well, a Pinto just blew up. This car was, it could drive. Wartburg was better than Trabant, yeah, because in the Wartburg, the elastic was put over twice, so it was quite twice as fast. Yeah, a sewing machine engine. It was such a bad one. Well, it was kind of cool if you were a hip young commie back in the day in Denmark.
A hip young
Yugo was the best. Yugo was a crap car. No, it's just because it was two-stroke engine. Is there a song with a Yugo in it? I don't know. Yeah, but I am born slightly before 1988, so I remember those cold mornings.
Oh, slightly. Okay.
Well, you live in Sweden. That's communist, so. Oh, there's videos for. It's yeah. You remember we are really close to the Eastern Bloc. A lot of people thought that communism they all win someday. Yeah, the blue smoke. Yeah. Oh, it was one of the worst cars. Well, you lived in Serbia. You probably couldn't even get a car back then. Yes, Sweden is communist. Sweden is hell, so of course it's communist. Hey, Aussie Tank. Good morning to you as well. Well, it couldn't be morning already down there. It must be. Isn't it like 3 in the morning? What's China doing? They're making electric cars. We have a lot of them. You have a divorce lawyer on the stand right now who is really editorializing everything. Other than that, a whole lot of nothing, actually. Not proving that she wasn't in the right. It just had a lot of police officers saying, yeah, there was holes everywhere after the 4 shots, and they called the police. We haven't really got into anything. This divorce lawyer is, I think she's the one who should be the leverage to really push it, but there's been so many objections, so it's never really been flowing, and she's editorializing every question. Didn't you have to be on a list? It's 1:15 in Sydney. Yeah, 8 hours. Yeah, sorry. $9:15 in Colorado. Well, it's 5:15 in Denmark. Well, in a communist paradise, you're always on some list. Editorializing, exactly. It's my accent. Well, the only thing we have heard is that they had a custody battle that wasn't that good. so far. What the F is he doing with that lawnmower? Oh, yeah, Atlanta Neva, that was a cool car. You must have had all your school teachers had the 12.7 as well, just like mine. No, you're not that old, are you? I was in 12.7.
All right, members of the jury, here's what we're going to do. I'm going to go ahead and let you go to an early lunch. It's about 11:20 right now. So the good news is you get to beat the crowds wherever you decide to go. If you could be back downstairs in that jury assembly room where you start each morning at 12:30, and we'll look forward to getting you back up here as soon as we can after that. Please remember, if you do go out somewhere and have lunch, if you go in a group, that's just fine. You can absolutely go in your groups, but do not discuss the case at all amongst yourselves or anything about the case. Don't talk about the case with anybody outside of the jury. And please don't do any legal research or research on the people, places, things, or legal topics we've heard anything about. Again, if you're sitting somewhere, you just kind of hear in the din of the people behind you something about the case, just let them know, hey, I'm a juror in this case. I need you to stop. If they persist, please leave and report it immediately to the deputies. All right, we'll see you back hopefully around 12:45.
12:45.
I don't know Secret Squirrel. Now he chucked him out for lunch.
All right, you're going to have a seat. The jury's out. Ms. Murphy, we're going to take an early lunch break. I want to remind you that the rule of sequestration has been invoked, so you're not to discuss your testimony or the questions asked of you with anyone, including the attorneys. You're not to discuss your testimony with any other witnesses or talk about what their testimony was or will be. You're not to view anything about
You're
this.
more than welcome. But I'm going to end this stream because I have to take Molly out, so I don't want my computer running.
All right, we'll see you guys back here at 12:30.
So guys, girls, countrymen, normally I'll put on words on screen, but now I have El Doggo, Mino. I have to take her out for a walk, so I don't want to have my my computer running while I'm out, if in case anything should happen. So we'll be back at 12:45. I redirect you over to the next stream. It's set up for 1 o'clock, I believe, but we will be back when court is back.
Okay.
Well, I don't know where she is.
You lost her already.
She's sleeping, Dream Server. You come back after lunch. I'll show her again. Food Fairy, that's called a teaser. You can see Molly after lunch. That's on insurances for. Yeah, I know.
That's so mean.
You all, you go have some. She isn't pooping on my floor. She's house trained. You all go get some lunch, breakfast, dinner, whatever time it is, wherever you are. Follow us on X and Discord, and we will notify you when we go back live again. Until then, enjoy yourself and bring in some of the funniest things that you can entertain us with while. Oh, that's the wrong button. I'm doing an expert. That you can entertain us with when we're back.
What exhibit are you referring to? I'm going to make this 100, Your Honor. All right. 100.
100.
Because it is 100%
100%.
correct.
Objection, Your Honor. So you literally built a cannon Yeah, it's pretty awesome.
All right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.
So there-
Everybody has.